This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I'm very, very grateful. I've got a great interview today with Chuck Michel, who's the volunteer president of the California Rifle and Pistol Association. Chuck is also a constitutional attorney. He's the senior partner at Michel Associates. He is also the one that's the founder, I guess you could call him, of the Second Amendment Law Center, which has a whole lot of great attorneys that are renowned Second Amendment attorneys as part of that. He's very, very involved in this battle. And so I wanted to have Chuck come on and explain to us exactly what does Judge Benitez's decision in Miller versus Bonta that struck down the California assault weapons ban, what practical effect does that have? What's going on at the Ninth Circuit with the logjam of cases? How will that be affected by the Supreme Court and all those kind of things? So Chuck is very knowledgeable. He's going to help us out with that. Before we get to the interview, though, let me remind you that you can support GunGuyTV a myriad of different ways. One way is to join us and join the GunGuyTV crew on Patreon. If you'd like to do that, there will be a link in the description. Another way to do it is to shop some of the companies that support GunGuyTV, which actually costs you nothing. You get to shop, you get a discount on a lot of things, and at the same time, they pay us a marketing fee. So let me show you the number of companies that support GunGuyTV with an affiliate relationship like this. You can see on the screen, there's a lot of them, and where you'll find those is going to GunGuy.TV. That's our website, GunGuy.TV, and on the top there's a little thing that says, a menu item that says discounts on gear. If you click that, you'll see the links for all of these. If you shop any of them, obviously you got to pay for your product, but it costs you nothing extra. The price for you is exactly the same, but it benefits us when you buy something. We get a little marketing fee, and for many of these places, you're going to get a 10% discount by using the code that's indicated on that page, so check it out. All right, let's get right to the interview with Chuck Michel. Chuck, thank you very much for being on the show. I'm very grateful that you came along. It's always nice to have experts, considering I'm not one, and you are. So I'm grateful that you're here to talk to us about what's going on at the Ninth Circuit. You sent me a blurb that you'd written that's on the CRPA website that explains some of this, but I'm wondering if you could relate to us what is happening with the Ninth Circuit, and particularly as it relates to this most recent decision in Miller versus Bonta.
Sure. Well, the most recent decision from Judge Benitez down there in the San Diego Federal District Court was obviously another in his series of three. It's the latest in his series of three great Second Amendment rulings. This time he held that the California quote-unquote Assault Weapon Control Act was unconstitutional and violated the Second Amendment, which of course we've known forever, but the anti-gun lobby has done such a great job of twisting the narrative, not just about guns, but also about the Second Amendment itself, that it's a bit of a rarity to get a judge who actually gets it. Judge Benitez is not alone by any means. There are a lot of judges across the country who have been true to the intent of the Heller decision from 2008 and recognized that the Second Amendment is not supposed to be some kind of a toothless anachronism. It's a meaningful amendment that protects the right to keep and bear arms for a variety of different purposes. But Justice Benitez, this is the most recent pronouncement by him to that effect, and he struck down the California assault weapon control law in his opinion. Now that has just made the anti-gun lobby go apoplectic. They are freaking out. Governor Newsom is sending out fundraising emails, believe it or not, for him to raise money to fight to keep the AWCA, the Assault Weapon Control Act is what it's called in the Penal Code. And obviously the mainstream media has gone nuts buying into this spin about an analogy that Judge Benitez did between an AR-15 and a Swiss Army knife, pointing out that just like a Swiss Army knife has multiple things that you can do with it, multiple utilities, diverse utility, if you will. An AR-15 and these modern sporting rifles also have multiple different things that you can use them for. Hunting, yes. Sport shooting, yes. Self-defense, yes. Other things. But they want to make it sound like as if he's claiming that a Swiss Army knife has the same degree of lethality as an AR-15, which of course would be ludicrous if that had been what he was saying, but it wasn't. But that's the kind of twisting that the complicit media and the politicians will do to try and now shoot the messenger, to demonize this justice. But as I said, he's not alone. There are a number of other judges that have recognized that Heller meant what it said, that the Second Amendment means something only if it has some teeth. And so this was his third decision that recognized that and actually paid respect to the Second Amendment in the way it's supposed to.
You know, Chuck, you mentioned a couple of things there. One was that the judge had really in his decision described the Second Amendment as a muscular right, that it's not a weak it's not a redheaded stepchild of a right. It's a muscular right. He used that term. The other thing you mentioned just a moment ago is that this judge is under attack, and he is. I've seen attacks on him in the media. He's being attacked by the left. This guy's done a wonderful job, but he's getting beat up pretty badly here in the public eye. How does that affect a judge? And if so, how?
Well, it affects a lot of judges. They're afraid of that. Judge Benitez is very unique in that his parents were arrested during the Fidel Castro revolution, and they were accused of being U.S. sympathizers. He and his brother basically snuck out of Cuba and emigrated to the United States. Then their mother came later. And so he has seen tyranny up close and personal. He understands the value of the right to keep and bear arms because his family suffered in Cuba under the Castro regime. So, and also, it doesn't hurt that he is a senior judge and getting ready at some point, we don't know exactly when, but sooner rather than later, to retire. So I think this is sort of his swan song in a way, to actually be able to say what he believes and what he thinks and what he has been able to demonstrate. It's not like he just makes this stuff up. If you read these long rulings that he issues, and there's been three. The first one was in Duncan, the CRPA's Duncan case, which challenged the ban on the possession of magazines that can hold over 10 rounds. We won that, and then the CRPA took that up to the Ninth Circuit, and the Ninth Circuit three-judge panel upheld that. We won again, and that freaked a lot of people out. Then Judge Benitez agreed with us when we filed the Rohde case with Kim Rohde as our lead plaintiff, who the Olympic shooter that we all know and love, challenging California's ammunition background checks requirement and internet ammunition sales ban. And he held that was a violation of the Second Amendment. And that is up in the Second Amendment in the Ninth Circuit now, too. And so he's in a position where he's somewhat isolated and can really speak his mind truthfully, I think. And so he is, and you got to hand it to him. I mean, he holds the state to their burden of proof. And by that, I mean, he says, well, you're saying that this law will save lives because it stops criminals from getting these guns, or these guns are more dangerous than civilians should be allowed to possess. Where's your evidence for that? And they don't have any. They put on these junk scientists who aren't scientists at all. They're ideologues masquerading as experts. And he sees right through that stuff. I mean, in the Duncan decision, he was quoting, the state was quoting an article from Mother Jones magazine, for crying out loud, as if it was evidence that supported their position. So he's just holding the state to its burden of proof, forcing them to justify an infringement on a constitutional right, and then calling them out on it when they can't, because they can't.
It's a fascinating thing to read his decisions, because knowing his history, he has seen oppression. He's experienced it. He's experienced a tyrannical government. And when he went through this decision, you could very much hear that from him, that the very things that as Americans sometimes we talk about being concerned about, he actually lived through. So he's seen this happen in a country that he was part of. It doesn't want it to happen in this one. And so it's he's a very inspiring character. I suspect, this is my opinion, I suspect that all this heat he's getting in his case is going to not affect him at all. I think he seems to be tougher than that. Wouldn't you agree?
Yes, I think he is. What concerns me is, this case was brought even though the CRPA already had a challenge to the AWCA in the Ninth Circuit. It's fully briefed, it's submitted, it's been argued. We're waiting on a decision, or we were at least, until the Duncan case. We won on that 3-judge panel, and it went up to the en banc level, which is an 11-judge panel. Remember, you start in the trial court, you go to a 3-judge panel at the Ninth Circuit. You can go sometimes to an 11-judge panel. There's even I think is a 25-judge panel in there that almost never happens. And then above that is the Supreme Court. And so the Duncan decision, there's still justices on the Ninth Circuit who do not like the Second Amendment. And this has been our problem since Heller and McDonald came down, is that there are certain judges who are ideologically opposed to, and by that I mean biased, against the Second Amendment. And so they have just mischaracterized and misapplied the standard of review and the test to basically determine the constitutionality of a statute. They've bent over backwards to make it possible for judges to put their thumb on the scales of justice and make a case come out however they want it to come out. And so when Duncan came down, the magazine ban, the challenge that CRPA brought came down on our side, and we won, first with Judge Benitez and then in the Ninth Circuit 3-judge panel. Some of those justices on the Ninth Circuit then immediately tried to get it in front of an en banc panel, and that's pending. There's going to be an argument on June 22nd. In the meantime, though, the kind of shrill response that Judge Benitez has drawn and the criticism that he's drawn, I'm afraid could scare. I mean, judges are not all judges at least, are insulated and isolated from political influence. And so this is what I was afraid of when they brought this case to begin with, because you could kind of predict that Judge Benitez, based on his earlier rulings, was going to see through the state's flimsy justifications for bans on semi-automatic rifles, and he did. But now that he's drawn all this heat, the justices on the Supreme Court are going to see that. The Ninth Circuit justices are going to see that. And we hope that they are brave enough, strong enough, committed enough to the law and to their oath to uphold the Constitution, that they will withstand that and rule reasonably. And so the CRPA Assault Weapon Control Act case is in the Ninth Circuit now. Again, I said it's been submitted, it's been argued, it's briefed, it's waiting a decision, except now it has stayed behind this Duncan en banc hearing that's scheduled to take place on June 22nd. And then also Rhodey is stayed behind that Duncan, awaiting that Duncan decision. And so the bottom line for Miller, the case that just came out on assault weapons from Judge Benitez, so-called, it is behind the Rupp case, the CRPA's Assault Weapon Control Act challenge. So Miller really, as a practical matter right now, that decision, although it's beautifully written and a pleasure and inspiration to read, it's not, I don't think, going to have any practical effect in the Ninth Circuit because there are cases far down the road ahead of it. And also, there's the Supreme Court case looming, the New York public carry case looming, which everything may be stayed while we wait for that decision, which we're not going to see till next June. But so as from a legal perspective, the most recent opinion gets in line behind these other lawsuits. It reads beautifully, and we hope the other judges will read that opinion, but not be afraid to rule the way they should because of the politics and that came out of it. So you don't go reconfiguring your rifle. Don't change anything. Don't turn a gun that's not considered under the law to be a quote unquote assault weapon into a gun that is, because right now, things are as they have always been. You can't create an assault weapon in the eyes of the law by reconfiguring your gun at the moment.
So the practical effect of this decision at this moment is it made us feel good, but it really hasn't changed anything for the moment.
And it's persuasive authority. It's not mandatory authority. No court is bound by it. But Lord, all of his, if you're ever going to read a court case, read those 3 decisions by Judge Benitez. If you appreciate the Second Amendment and the right to keep and bear arms for yourself and your children, I mean, really, they are just phenomenally written and compelling reads that everybody will benefit from.
Well, they're almost like a class on how to defend the argument for the Second Amendment. He's a phenomenal writer. He really is. And you and I have discussed before that a lot of attorneys are outstanding attorneys, but not the greatest writers. And the combination is sort of a rare thing. When you find it, you jump on it. It's a sad thing to hear that he's getting older and might want to retire.
Yeah, and I don't know if we're going to be able to, the reason he was hearing all these cases is because San Diego has a related case rule, the San Diego District Court system, where you can, if your case raises similar issues and similar parties and similar legal issues, you can relate it to another case. And this is something that we suffered from years ago when the municipalities were suing the gun industry, trying to put them out of business by accusing them in court of being responsible for the criminal misuse of their products. And there was a very, very liberal judge up in northern New York who they kept relating cases to, and he kept taking them and he kept ruling against the gun industry until he was finally overturned. But they use this, some of these jurisdictions have these related case rules. And so I was familiar with that. And when we filed the Rhodey case, we used that to relate it to the Duncan case and get in front of Judge Benitez. Unfortunately, after that happened, every lawyer on the planet who thinks he has a Second Amendment case started filing in San Diego and then filing notices of related cases. And ultimately, it made the papers. And I think there's going to be a lot more reluctance to interpret that related case rule broadly so that more cases can get in front of him. But we'll see. I mean, right now he still has a couple other cases, a billy club case. I mean, come on. Why do you need to litigate that right now? Some people. Wait a minute. Hold up.
There's a billy club case?
Yes, trying to make an argument that because California has certain limitations on billies.
Right, billy clubs a little bit on some knives and like that, like most states.
Right, all these, and then there's
sort of ancillary things.
Case.
Yeah,
there's a knife case working its way through too, and so some guy wants to be able to use a nunchucks at his dojo, and they're restricted, or a butterfly knife, and so they're bringing these Second Amendment cases to protect those kinds of things. I mean, that's premature. Guys, that's not the kind of thing that we need to do right now. And that's where people need to understand there's a difference between impact litigation, where typically you will have an association like the CRPA and 3 or so individuals, all of whom have very clean records and are, model citizens who become your representative plaintiffs, and maybe a couple other associations, so that you don't have to worry about standing. You don't get sidetracked with these procedural things about whether or not you have legal standing to challenge whatever law you're challenging to begin with. That's impact litigation, where you're trying to make a legal precedent that will benefit everyone. And then there is this individual litigation where some guy wants to, like I say, have nunchucks in his dojo. And so one person files a case that could and typically it's underfunded and the lawyers aren't great writers, which is really what I mentioned and you we're just talking about, to do a good job. They don't have the resources. And so to try and advance some individual's agenda, they risk the setting bad precedent for everybody. So this is another frustrating thing that's happened since, frankly, McDonald came down. Every time a lawyer thinks he sees an open issue, an unresolved question, he thinks it's his duty to make a few bucks off it and try and challenge it at the risk of getting very bad law.
Yeah, no bueno. I have a couple of questions here for you. One, you've mentioned a couple of things I just want clarity on. One is, in fact, I even entitled this a 2A logjam at the Ninth Circuit for a reason, because we're stacking these things up at the Ninth Circuit, which is honestly very exciting, but at the same time takes a long time. And you mentioned the New York case in there. I guess I would have two questions. One, can you explain why there is a logjam at the Second Amendment? Where the Second Amendment is concerned at the Ninth Circuit in more detail. And is this something we should be frustrated by or something we should be patient with?
I think it's okay. So the reason that there's a logjam is because the standard of review has not been decided by the Supreme Court. The reason there's a logjam is the Supreme Court has not addressed the Second Amendment since 2011 in McDonald, and then 2008 in Heller. So, and we know the standard of review, the appropriate level of scrutiny that a gun control law should get from a court when determining whether or not it's constitutional or whether or not it violates the Second Amendment. That standard of review has not been set by the Supreme Court. So multiple circuit courts of appeal have set slightly different approaches to determining whether or not a gun control law is constitutional. And in the Ninth Circuit, they've set up this two-part test that first asks, is it even within the scope of the right? And it's very easy for them to say, oh no, it's, anything outside the home, not even protected by the Second Amendment. There is no bare arms in the eyes of the Ninth Circuit. So courts can play these games with this about this step process to figure out whether it's constitutional. Well, the Supreme Court is quite likely going to change that whole approach and mandate an entirely different approach, an approach that it outlined in Heller, but that everyone has twisted. All the lower courts that don't want to follow Heller have twisted that standard of review so that they can uphold a lot of gun control laws. So now the Ninth Circuit sees the writing on the wall, or at least they see it for the Duncan case, because we won in the 3-judge panel, and now they're going to send the standard of review question in the context of the Duncan case to the en banc 11-judge panel. But the reality is that's also premature. So you've got Duncan, which could determine the standard of review, has Rohde, Roop, Miller, all backed up behind, in a couple other cases, all backed up behind it, all stayed pending the resolution of Duncan. But the real question is, so that backs up the whole Ninth Circuit. The real question is, shouldn't Duncan be held until the New York Carey case is decided and the Supreme Court sets, for once and hopefully for all, the appropriate standard of review, and in doing so gives us a Second Amendment with teeth, because then the tests that have been applied in all those other cases would be out the window. We have a hard reset, and they have to apply a different, much stricter test along the lines of the one that Judge Benitez has used to determine whether or not a gun control law is unconstitutional or not.
Do you feel like there's a good chance that case will be stayed precisely for that reason, so that the Ninth Circuit can see where the Supreme Court is going to take this?
I don't know. They certainly know about the Supreme Court case, and we made them aware of the fact that the Supreme Court had accepted the case. So they know it, but they nonetheless scheduled the oral argument for June 22nd. So it's coming up soon, and folks, you will get a much better idea of whether or not they think it's appropriate for them to rule before the New York State decision comes down from the Supreme Court, when we hear how they approach the questioning in that oral argument on June 22nd. I mean, it's coming up in 2 weeks.
So I'm going to ask you to prognosticate a little bit. Let's say that they do not stay that decision, but rather they just go ahead and decide it. What does that do? Obviously, I assume that doesn't affect the Supreme Court's action, whatever they're going to do. But where does that put us in lieu of that? I mean, how does that change the strategy or change the makeup of where we are and where we're going?
Well, Judge Benitez has been very careful to apply both the standard of review that he thinks is appropriate under Heller, which we think the Supreme Court will agree, but also the Ninth Circuit's two-step process and interest balancing, and influence the decision by interpreting the facts and the law in subtly different ways to make it come out the way you want. Well, if we get the right judges on that 11-judge panel, and it used to be very unlikely that we would, because there weren't enough conservative justices. And I don't mean to imply it's quite that simple. It's not like conservative justices always rule pro Second Amendment and liberal judges always rule against. If you think about it, if it's a constitutional right, this should be, the Democrats should be the one that are arguing that the Second Amendment should have teeth. But it used to be 2-to-1 judges appointed by Democratic presidents versus judges appointed by Republican presidents. Now it's even, and even a little more heavily balanced towards Republican appointees. So if we get a majority on 6 votes on that 11-judge panel, we could win no matter what the standard of review is in the Duncan case. And then that would be the precedent that would be applied to Rhodey, Roop, the CRPA's challenge to the semi-automatic rifle ban, and Miller, the Judge Benitez's recent opinion, and whatever else they may have up there. So we could still win even without waiting for the Supreme Court to rule. I just don't understand why they would try to, why they would try to decide that. We're not going to see the decision out of the Supreme Court for a year. They'll argue it next fall. They're briefing it this summer. They'll argue it next fall. And typically the court renders its decision in the most high-profile cases at the end of its term, which would be next June. So we're a year from hearing from the Supreme Court on what the Second Amendment means. In terms of, in Ninth Circuit jurisprudence, that's not that long. They can sit on a case, and often sit on a case, for a year or more. So, as I said, the best indication of where they're going with Duncan and where those other cases that are backed up behind it might be headed is probably going to come from the comments and questions that the judges make on June 22nd on the Duncan oral argument.
And we'll be watching that very, very closely. You have mentioned a couple times the assault weapons case that CRPA brought, and then we have the one that Judge Benitez just ruled on. Are they, and forgive me, I don't remember, but were we victorious in both of those, or did one go one way and one with the other way?
No, we filed the challenge to the Assault Weapon Control Act before we found Judge Benitez. So we lost in the trial court, candidly, but the 3-judge panel that we argued in front of was very sympathetic. They saw through the baloney. We had a couple of judges on there who really were very much insightful, like Judge Benitez has been. The state is basically arguing that any gun that's too accurate, not just fires too fast or whatever baloney statistics they may try and attribute to semi-automatic rifles. They're basically saying that a gun can be too accurate for a civilian use. They can ban a gun based on how straight it shoots, because that's what the AR with the recoil control, the minimal recoil on an AR platform, it makes it more accurate. And so the state wants to say you can't have a gun that shoots that straight. And so the judges were incredulous about some of the arguments the DOJ was making. And this is what's perhaps the most, from my perspective, trying to get to the truth and get a court to recognize the truth. This is where these cases smoke out the DOJ's preposterous positions. And they really have to start arguing these things that don't pass the red face test. And so more and more judges, I think, see through that. Judge Benitez certainly did, and a couple of the judges on the Roop appellate panel did. So we're very hopeful. But that's, again, stayed frozen pending Duncan.
And so we wait. Well, I tend to agree with you. The preposterous arguments are starting to be seen as just exactly that, the idea that civilians should be given inaccurate guns that are hard to shoot. Makes no, as a longtime instructor, I am pretty clear with my students that they are responsible for every round from the moment it leaves the muzzle until it stops and any damage it does along the way. So if they have to shoot at some bad person trying to hurt them, they need to make sure they hit them. So the more accurate, the more easily controlled, the better. So it's an absurd argument. I agree with you.
Yeah, well, when I teach the law of self-defense, I tell them every bullet fired in self-defense has a lawyer attached to it. You're going to get into a legal dispute. It really becomes a matter of, it's life or death, so I have no choice. Then you take whatever consequences come after that. It's better to have to face them as you're alive. But yeah, you're right. I mean, you don't want a gun. You don't want a gun.
No. I want a gun that's really difficult to shoot that I can't hit anything with, and I want to defend myself with it.
And misfires a lot.
Yeah, exactly. So it doesn't make a lot of sense. Hey, I wanted to ask you, because we talked about it briefly once before, you've started a new thing, the Second Amendment Law Center. And can you kind of update us on that? What's going on with that?
Yeah. Thanks for asking. Yeah, well, so, I'm the volunteer president of the California Rifle and Pistol Association. Because I didn't have enough work to do running my constitutional law firm. But the CRPA is growing, doing great. A lot of people supporting it. A lot of people recognizing the cases that it's bringing to advocate for California rights. But more and more, as the NRA is sidetracked because of its financial difficulties, and as the Second Amendment expands, I anticipate that it is going to become much more robust after the Supreme Court rules. And there are already cases all across the country, not just in California, that really need to be brought to stand up for Second Amendment rights. And so there's a vacuum to some degree now because of the NRA's predicament. And so I formed the Second Amendment Law Center as a nonprofit 501c3 with all the A-team Second Amendment lawyers from across the country on my advisory board and legal team. Steve Hallbrook, dozens of others. And so we will be filing amicus briefs based on the scholarship and knowledge that these legal scholars and experts have in cases across the country and in the Supreme Court, and then bringing cases, appropriate, strategically well-chosen cases, as opposed to, throw the spaghetti against the wall and see what sticks type cases, which some other groups do. To advance Second Amendment rights, not just in California, but all the way across the country. So, and remember, when you get a good precedent in another state from a federal court on a federal right, like the Second Amendment, it applies all across the country.
Chuck, is this, with all the things, I mean, I don't want to go through the litany of negatives that you see in the news every day about every aspect of everything. But where the Second Amendment is concerned, should this be for gun owners an encouraging time, or one that we're hunkered down and freaking out about? What would you say?
Well, I'd say it's the Chinese curse. We live in interesting times. We are at the cusp of a major development now in Second Amendment jurisprudence. We had a huge development in 2008 with Heller, a less significant but certainly important development in the incorporation case, the McDonald case, that said that state and local governments are restricted by the Second Amendment, not just the federal government. And now we're going to get some kind of a review of what the appropriate way to evaluate the constitutionality of a gun control law is. And that it's frightening, it's exciting, but it's above all very, very interesting, because it's going to set the tone. It's going to set the standard that we use for, 100 years. This case is right up there with, Roe v. Wade or gay marriage in terms of its significance, only it's on the other side of the political spectrum. So, and you can read the tea leaves with the justices on the Supreme Court. We know we have 4 friends, but how far will they go, and what kind of restrictions will they put on governments trying to pass feel-good laws that don't have any effect, which is what 99% of these laws are really all about. So it's just a very, very, it's exciting time for lawyers, an interesting time for everybody, But yeah, there's a little bit of nervousness that, the Supreme Court is hesitant to go as far as I really think they should.
Chuck, thank you very much for being on the show. I'm so grateful for the fact that you come on. You clarify a lot of things that really need to be clarified. So thank you, brother. I appreciate it.
Thank you for helping me get the word out. Thank you for supporting the CRPA and Second Amendment Law Center. Joel, really appreciate everything you do. You've got a great platform, a great message, and I'm proud to be part of it.
I'm grateful. Have a great week, and you be safe. All right, brother?
You too.
Thank you very much for watching the entire interview. I'm very grateful, and I'm super encouraged that you are staying informed. That's one of the most important things that you can do. You can't fight the battle if you're not informed as to what's going on. Speaking of which, as far as fighting the battle is concerned, I do urge you to support the California Rifle and Pistol Association and, for that matter, the Second Amendment Law Center that Chuck has started. And I'll put links for both in the description. If you support them, they can continue the fight. Keep in mind that NRA, which used to fund a lot of these lawsuits, isn't anymore because they're fighting for their very existence. So groups like the California Rifle and Pistol Association have had to step up and actually fund these lawsuits on their own. They need every bit of support they can get from you. So please do support CRPA, and I urge you to support the Second Amendment Law Center as well. Thank you again for watching. Have a wonderful week, and wherever you go, whatever you do, be safe.